Thank you, everybody. Welcome to the Graebe Subcommittee meeting. I actually, Brian, do not have a copy of the conflicts policy right now, and I think it has to be read verbatim. Is that right? Or can I just ask folks to
It
discuss?
Sorry, I was dealing with the live stream, so I didn't have double microphone going on. I believe you probably want to advise the members of the subcommittee of their duty under the State Government Ethics Act to avoid any conflicts of interest and to disclose any conflicts of interest at this time.
Okay, you all heard that. Does anyone have a conflict that they need to disclose?
We've been so advised.
Okay. And if at any point in the conversation you realize you have a conflict, you'll just let us know. So welcome everyone. So as a reminder, because I know we're all on many subcommittees, this is our Graebe inquiry. It's called the Graebe inquiry because it came from Will Graebe at Lawyers Mutual. But we know this is about whether or not lawyers should be able to include in their representation letters or in their client engagement agreements a provision that a client will pay fees related to subpoenas or depositions or additional costs related to the estate litigation if that becomes necessary at a later time. And those of you, hey, Stacy, welcome. Hey, Todd. And those of you who have been on this committee know, and Gina, you were my predecessor in leadership, and we still haven't gotten it resolved, that we have spent a lot of time talking about this. I don't think there's anything else for us to raise or say about this topic that has not already been said. I did miss the last Bar Council meeting, but I know that in March there was also really good conversation in the room at the Ethics Committee meeting about this issue. So Suzanne has, as we all know, tried repeatedly to come up with an opinion that will work for us. And so she's made a proposal today that she sent out in advance of the meeting. So she sent out two different documents. One was a memorandum that sort of talked about the progress that we've made over time. It shared that we had consulted with Carl King, who is the ethics chair of the estate planning and fiduciary law section of the NCBA, that we had looked at provisions in the American College of Trust and Estate Council documents, and that the estate planning and family law section of the NCBA had discussed this issue at their April meeting. He had also, a colleague did some research and found that at least 4 examples of law firms who are already putting these types of provisions in their representation agreements. That is on page 2 of Suzanne's memorandum. Suzanne, I thought that was very helpful. Thank you so much for including that there. And then Suzanne also included that there was a recent opinion on this from the South Carolina. It's a very brief opinion, but concluding that such a provision in your agreement with your client was permissible. So Suzanne, with the help of Brian, has drafted a proposal for us to review today. She did send out a revision about 25 minutes ago, if you've had an opportunity to look at that. But so now I'll turn it over to Suzanne for anything I've missed that she wants to tell us about, and then perhaps to talk us through the opinion.
Thank you, Ashley. That was great. As you all know, this has been around for a long time, and I think we've gone down some different tangents and gotten bogged down on some different things, but I feel like I've come to the conclusion that these types of fee provisions should be permissible. In fact, they're already being used by a lot of different well-known law firms, and I think if we were to come out with an opinion that said they weren't allowed, we would get a lot of pushback from that. And just from all the discussions that we've all had, I think there's a lot of reasons that they should be permissible as long as they are carefully drafted. And the final opinion that I sent out for you guys to look at, basically the beginning is the same from the very original draft opinion, which was like 100 years ago, which said that the fee provision proposed by the particular law firm that they got from ACTEC is not permissible because it's too vague, lacks in specificity, and it could potentially lead to clearly excessive fees. There was no exceptions for malpractice, poor drafting on the part of the lawyer, just basically too broad. And so the original opinion said, no, that provision that you're looking at is not okay. But we don't want to say that any provision allowing for future fees and expenses is not okay. And what we've done, and that's where the original proposed opinion stopped. But what we've done with the new opinion is we've gone through and said what is necessary to make the provision acceptable. And there's like three basic things. It needs to be, the scope needs to be limited, the ultimate fees and expenses need to be reasonable, and it needs to be clearly articulated to the client, and the client needs to consent to that. So the new draft goes through and talks about the three things that are necessary to make it permissible. And it also refers to the South Carolina opinion, which says these are okay. And then we do give an actual illustration of a provision that we think would be okay. One thing, the hardest thing for me, and Brian was helping me with this, is kind of figuring out the fee, how the fee should be determined in the future. Obviously, the fee provision that we got from ACTEC said that the fee would be the lawyer's hourly rate at the time of the discovery or the deposition or the testimony. And I think a lot of people had problems with that because you really just looking at how fees have gone up recently, it just seemed like that could be a really shocking number for the estate in the future. It's just the unknown of that. People felt uncomfortable with that. So we were trying to look at a lot of people suggested maybe putting a cap on how far up it could go. Well, that's what we tried to do in the section on the fees. We said that you can allow for the fee to go up, but there needs to be some cap, and you need to base that either on some percentage per year or just a max of whatever the hourly rate is, 500, 600, whatever the cap is going to be, or some combination of that, but that ultimately it has to be not clearly excessive. That's about it.
Thanks, Suzanne. So I'll recap and then open the floor for questions. So just to recap, so Suzanne answered the original inquiry by saying, no, this provision is too broad. So we've all read that opinion. And then the additional language says, but there could be instances where such a provision is acceptable. And then they've tried to outline what that might look like. And there is a sample provision, which I thought was very helpful, on page 4 of the document that Suzanne sent us, which is by way of illustration, the following provision would be acceptable. So with that, what questions or comments does the group have?
I will say that sample, I think Brian came up with that, and it was kind of a combination of looking at what other law firms have been doing, and then adding in some language that we felt was necessary to make it pass muster under our rules of professional conduct.
We got two questions for you, Senator. What you think on the percentage increase per annum or maximum rate? Any heartburn that you would have by saying or the greater of the two, whichever one would be the greater?
You can say the greater or the lesser or basically what it says now is any combination of factors, and I don't know how specific.
I think that's good. I think it's catch with the call in, but I want to make sure that wouldn't, if I said, okay, I'll put in or the greater of as a practitioner, that wouldn't cause you to have heartburn saying this would fall outside of this particular provision because of any combination of the two. I think that's good. That language may catch it. I just want to make sure you felt like it would. Initially,
I was thinking it would say or the lesser of the two, but that was just.
Oh, we're lawyers, Suzanne.
I'd have to, as long as it's reasonable. It's not not clearly excessive. The South Carolina opinion talks about reasonable because that's what their rule says. Our rule says not clearly excessive.
Mm-hmm.
So I was trying to provide examples of how you could have an adjustable fee, but without getting too into the weeds. So I don't think that precludes saying the greater of the two if ultimately that's not clearly excessive.
Okay. All right, which that will be because I guess the ultimate thing will be who's the arbiter of clearly excessive will be the court if it's ever challenged.
Well, that's the way it is with all 1.5A questions about the reasonableness of fees.
Yeah.
There's other, as far as making the fee adjustable, you can always do like consumer price. There's a lot of different things that you could look at, and
Right.
I'm interested to hear what you all think about what should be in there as far as providing an adjustable rate with some caps on there.
Gina, did you have a comment?
I just think I think it is an absolute masterclass in how we're supposed to do what we're asked to do. I think it is perfect. I wouldn't change a thing. Absolutely, Martin. The language or some combination of factors, but anybody's definition is going to cover you in your greater of. There's no doubt about that. And I think what Suzanne does is she tips, it's more than tipping her toe in. She's sticking her leg in the water and saying, here's some ideas, but you guys are on your own. Just don't be excessive, and be clear, and no surprises, no ambushes, no crazy town. I think it's just great. As I told before the live stream started, I thought this was an unsolvable problem before I vaporized for a few months, and I came back and I read this today and I was like, Suzanne and Brian, you probably helped a little bit. I think it's perfect. I'm thrilled.
Oh, thank you, Gina. That is a full vote of confidence. Judge, you got a comment?
Yeah, I'm very happy with this opinion too. This took a lot of hard work, and Suzanne took into account a lot of the concerns that everybody had. We did have the benefit also of South Carolina having weighed in, the Bar Association and other entities. So that was helpful as well. I don't think we had that at the outset.
It was pretty recent, and it's, I don't know if you all have read the South Carolina opinion. It was included in the materials, but they just basically said, this is fine.
Yeah.
And they didn't really
I guess it would
seem too bad out of shape about it.
And I guess it'd be up for a court to determine if, as a factor, whether you're doing legal work or acting as a lay witness. We're just going to defer that to the court.
Yeah.
Brian, you want to take that one?
Yeah, well, we actually took out the word legal for fees, because the Rule 1.5 talks about fees that a lawyer charges. And rather than tackling whether or not this is legal work or this is witness time spent as a testifying witness, it seemed like something that we don't need to get into those weeds of articulating one or the other. But yeah, ultimately, it's kind of the practical effect of submitting this. Let's say, we have this in a fee agreement, the client consents to it after, being fully advised and the language is clear as to what is going to be charged. And you find yourself 20 years down the road in some sort of, caveat proceeding or whatever it might be. And a lawyer who just testified goes and submits a bill for their time. That is still going to be subject to some extent for court approval because it has to go through the estate process. It has to be approved by the clerk. And so there is a safeguard there as well. The contract essentially gives the lawyer, I guess, kind of paves the way to be compensated, but it's not going to be that it's kind of the lawyer's way or the highway. There still will be some level of review. And that's what made me personally feel a little more comfortable seeing the practical effect of this, and seeing just how this could get carried out. But that's why we removed the word legal, because I felt like we were starting to get into some that you talk about an unsolvable problem. Is this a legal fee or is it just a regular fee? And when it comes down to 1.5, it doesn't need to be necessarily distinguished, but it is kind of a part of the factorial analysis, so to speak.
And do we need to address the contingency that the drafting attorney may no longer be practicing law? He may be an assistant district attorney somewhere. He may be a judge, or she may be a judge. determine the
Yeah,
prevailing
I-
rate at that point. So maybe that
Can
needs,
somebody mute him, please?
Yeah. Yeah, I mean, I don't think we need to address it in the opinion. And I guess I say that not to say that it's not something that is concerning. You're right. If you have a judge that's potentially collecting on an old contract for appearing as a fact witness, that's a really curious question. I would prefer to cross that bridge when we come to it, when they call for ethics advice,
okay,
as
fair
opposed to drafting an opinion.
Well, and to that point, I mean, the other thing that you have to take into consideration, maybe Martin could tell us what the average distance in time between the execution of a will and the death of the person who executed the will and the caveat proceeding or whatever happens. I mean, it could be decades and decades and decades. If you're smart, you do a will soon after you get married and have children. Maybe that's in your 30s. Nowadays, you're going to live to 100. I mean, we're talking about 70 years later. So that's why it's a big deal on having a little bit of a mechanism, because it would be obscene for the lawyer to only be paid what he or she were billing 70 years earlier. And then it would be obscene for a client not to be able to anticipate what legal fees are going to do for the next 70 years. So I think it's all covered in here. I think everybody's protected.
Yeah. The highest propensity I see of caveats filed are within work done within usually a matter of months. It may be a matter of a few years. It's not attenuated normally. I mean, I not to say it wouldn't happen, but the proof issues you run into as far as from an individual wishing to bring that caveat are really, really high. And then when you start talking about someone who has engaged in this activity of drafting this will, say 15 years ago, and since that time, they happen to give the person who is filing the caveat a car, or they've deeded them a piece of land. There's some case law in there that talks about the fact that you can't accept the benefits and then turn around and challenge later. You don't come in and out of competency fairly regularly. And so as a practical matter, I think that you're looking as far as with regard to caveats, it's normally something within the last few years of life.
Perfect. Okay.
Yeah, just as a practical
Even
matter.
easier. Yeah.
So Todd or Stacy, do you have any comments, questions, or concerns?
I also think that Suzanne and Brian have done a great job. The only area that I would maybe point out in the paragraph 2 on page 3, I maybe would do bullet points on those, just because when I'm looking at rules, I like, okay, if it's not a party, and do you see where the scope, it starts with the scope of the provision must be limited.
Mhm.
The law firm is not a party, and the competence or negligence. So that's number 1, can't be clearly excessive, and minimize time and cost, and clearly communicated. So I think there are 4 points that you listed in that. I think that's great. I would just can we do bullet points for those?
Sure.
Anyway, I like it. I think that also examples are great for me when I go back to the rules, and I think that the illustration is really helpful. So thank you.
Thanks, Stacy. Todd?
Yeah, I've got a couple of questions. Looking at the provision that you've offered as an illustration, can you tell me the difference between number 1 and number 3? Seems to me they're the same. The tail end of number 1 seems to duplicate what is stated in number 3 in your illustration.
Right, you're saying this phrase, or our work for you in the representation, and then number 3 says the request for information arises out of in connection for our work with you.
Correct.
Yeah.
Seem to be the same.
I see what you're saying.
We don't,
You can probably
I
consolidate.
assume you don't need number 3 if it's in number 1.
Yeah, I think you're right, Todd.
Yeah, you can pull that out.
Brian, is there any difference there that you see?
No, I think you're right. I think number 1 starts off talking about the reason for the request. but then has that tail end provision that duplicates in
Right.
number 3. So yeah, I think you're right. It can be removed.
Thank you, Todd.
Question, did you ever get did Carl King or Aztec ever issue a report of their meeting that this memo said was supposed to happen in June? Did we
No.
get anything from
No, I found their agenda. I don't really think they talked about it, honestly, and they did not come up with any new language to my knowledge. I mean, I think they said they were going to look at it some more and they haven't. But I have followed up with Carl again. And if I get anything that I think would change this or add to it, then I would certainly contact everybody and let them know that.
Well,
But
this would
no.
ultimately go to the ethics committee, I assume, essentially for publication after that. But when's the last time you talked to Carl? I would hate for us to issue something and then ACTEC come out with something that.
I've talked to him pretty recently, and as
Okay.
far as he wasn't there. We both looked at agenda items and have not been able to see where they came up with any language.
But it was his understanding that they are supposed to study this precise issue. Is that your understanding?
Amongst others, yes, but it
Okay.
hasn't happened.
That's fair. And is it still the case that only South Carolina has addressed this issue to our knowledge?
I believe so.
Okay.
I looked yesterday to see if there was any more ethics opinions, Todd, since the South Carolina one, and I could not find any.
Fair enough. We're obviously educating the bar with this opinion for clients and the bar and everybody else, any stakeholders. The question I have is, if we're educating folks, I mentioned this before, 6-21-2 addresses, as I said before, that the judge decides what the attorney's fees are in these caveats procedures by statute. So that regardless of what provision somebody puts in their contract, a fee agreement, if this statute applies, and I think it does, the judge is going to say what attorney's fees and expenses can be collected. Is that not right? So I guess I'm asking, if we're educating folks, ought not we mention this statute in this opinion, as opposed to letting folks think that whatever I say in my contract is going to be how things end up, because 6-21-2 clearly says the judge decides that attorney's fees and cost issue.
I mean, we can put a footnote in, we can put a section.
Well, I can't imagine it educating the bar not mentioning a statutory provision that applies, unless everybody on the call thinks it doesn't apply.
Well, would it apply if we're dealing with, this lawyer is not a party and he's not representing one of the parties during the caveat, right? This is for work he
Correct.
did.
That's what I was wondering.
We don't know.
No, he's
Yeah.
not. I mean, we're specifically saying that he's not a party to the proceeding.
But the law firm, I guess I read this to say that the court determines who gets attorney's fees if there's merit. And I guess the question is this statute relevant or not? It seems that it is relevant to this issue if we're educating our bar.
Martin, you experts on this?
Would you mention it? Just
You're muted.
You can put in a footnote. I don't care where you put it, but I'm just saying for purposes of educating the bar, this provision seems relevant and it ought to be somewhere in this opinion, perhaps.
even if just to distinguish.
Well, the statutes dealing with the attorney fees that allow normally are through 28A. And so on 6.6 where is it? I'm going back to
6-21, section 2
is just pulled up. Hold on one second. Let me go back to it. That I think
it says in any provision that any proceeding under this provision, the judge decides attorney's fees.
these deal like with notes, conditional sales contracts, or evidence of indebtedness, which I guess you could say this would be an evidence of indebtedness.
What are you looking at?
6-21.2. It's the preamble to it.
Yeah, okay. I'm looking at the language in number 2. It just says
Number
in
2.
any proceeding, the court shall allow attorney's fees. So it says the judge aside. What are you maybe looking at different things?
Yeah,
Yeah,
I think you're
6-
looking at 621, General Statute 621, and it's provision 2, subparagraph 2, not 621.2.
That's right.
I was looking-
6-21, subsection 2.
Okay, that's a
Yes.
different section. I'm sorry. Hold on 1 second. Let me go back to that one. I was looking at the one for notes. Hold on. Thank you, Brian, for clarifying that. Let me look at it. That's going to be on caveats and wills. That's the court cost. Right. That's exactly what
And
the judge
attorney's
with the
fees.
caveat. You're exactly
Yeah.
right.
Does that not address the attorney's fees of parties?
That's what I thought.
Yeah.
It says the court shall allow attorney's fees for the attorneys of the caveator. My point is it's relevant one way or the other to who gets fees.
I agree with, I agree with Todd. I mean, with that statute out there, we at least need to mention it so that a lawyer doesn't come in wanting to collect from the judge. The judge will be educated, or the clerk will be educated, like, hey, no, you're appearing as a witness in this matter. This contract that's supported by this ethical opinion applies, not rule 6 point whatever. Right?
Maybe if you want to footnote it and put it in there somewhere, or at least make reference to it, or refer attorneys to it so they can see it.
I
But as
agree,
far
it
as the
should be in there
application-
somewhere. Yeah,
Okay.
I don't care where you put it. Maybe it needs to be in a footnote or something. Just
On the
so
back,
folks
on
know
the
it's
back
out there.
page,
Yeah.
On the what?
on the back page where nobody sees it.
Mm,
I'm teasing, Todd. I'm
I
teasing.
know you are, but it needs to be in there somewhere because it is.
I will put it in. I promise.
Let me ask a question. We're basically saying to all practitioners, and I got a question on that too, that if they follow this example in here, they basically have a safe harbor that the grievance committee cannot come after them for anything dealing with that provision in their agreement because the ethics committee has put out an opinion saying that if I follow and adopt this illustration, this sample language, I'm good. Is that right?
Yes.
I think the sample language is good. What they do with the sample language or how they actually implement it is going to be the question. Like it's not supposed to be clearly excessive fees, but if you have a $2,000 an hour charge that you come out with per annum or whatever, it's that even though it says it's not supposed to be clearly excessive, if you are clearly excessive, the grievance committee will be able to enforce the rule on 1.5. So I guess that's I don't want to say that this is a clear safe harbor and anything you charge, anything you do with that language is going to be protected. I think this language is supposed to just give direction to practitioners. How do you capture what you're intending to do? And then you got to follow it, but it still requires some independent judgment to determine what is clearly excessive.
I agree, but obviously in grievance, if something comes up, then somebody's going to say, I'll follow this ethics opinion, and so you can't sanction me. That's clearly what's going to happen in grievance, and we know that.
Yes. Yeah.
And so
And
I
feel like we see that as well.
So I guess my point was, Brian, we're sort of obviously working in tandem, and we don't want to put something out that undermines the authority of the grievance committee. Ought we run this by the grievance chair? If you haven't already, just to talk with him or her to see what they think about something like this?
Yeah, I mean, we've never done that with any ethics opinion.
We've gotten feedback from them after it's been
Yes.
published for comment, just like like other lawyers we've gotten.
Either way, we could. I mean, we can let Kevin give us feedback after we issue publication. But either way, Kevin's the chair of the grievance committee. Then he's gonna. I don't know that we need to wait to ask his opinion because he may have some issues that might be relevant to the subcommittee before it goes out.
Right. Yeah, I think that's, and it raises an interesting question about the autonomy of the ethics committee. They are the ones that are empowered to issue these ethics opinions, and I think it was kind of created with this split between the two as far as figuring out what the rule should be versus the enforcement. And I know, to your point, Todd, recently wire fraud, we've had those ethics opinions on wire fraud, and I've continued to receive questions, particularly some that I think are coming from grievance about just how to enforce this. And I think it becomes this tough thing of how detailed do we get in these ethics opinions to provide a pathway for grievance? At some point, grievance is going to have to make a call whether or not somebody did or did not violate the rules. And this ethics opinion, I guess, well, we'll just kind of provide that background. I was in a camp of no, this can't happen before, and seeing how this all played out, it feels like there's enough here for lawyers to exercise their independent judgment to determine what is appropriate. And I think it still provides the grievance committee the ability to take a look at this and say, well, this is the language, but ultimately what we look at is not so much the language, but what you did, lawyer. And I think that's to me, that's where I feel confident in the opinion, at least for publication right now. I'd love to get feedback. But going to the grievance committee and getting kind of a green light on an ethics opinion before publication would be something that we've never done.
I'm not suggesting getting a green light. I'm just suggesting
Okay.
let them look at it and get the feedback, just like we're going to get feedback from all 32,000 members of the bar.
Oh, absolutely. Yes. That's why we include a copy of all published opinions in the council materials.
Okay. Well, just make a note. I'm thinking we might ought to just get some feedback, because Kevin will clearly give it, or the grievance committee will give it. I just don't want the ethics committee to do something that might undermine the grievance committee later down the road. Because in this opinion, we're saying at the top, this is not an acceptable provision, obviously, that we got from Lloyd's Mutual. At the bottom, we're saying, here's one that the ethics committee is saying would be acceptable.
Mm-hmm.
Suzanne, Ron, would it be better to leave, instead of giving a stamp of confidence to 3% increase being okay? Would it be better to leave a blank there or an X?
I had an X there at first. I don't know the answer to that. I had an X there at first, and I was just going to ask you guys what you thought is a reasonable per annum increase. And
the reason I asked that is, if you look at the bottom of your opinion, the last sentence is actually really pretty. I mean, it does great, because it says any fees and expenses charged to client or client's estate shall not be cleared excessive, and law firm will make a reasonable effort to minimize time, cost, expense related to such a request. By having that last sentence in there, it puts it back on us or me as the lawyer to make sure I'm still not being excessive. And so I don't get out of it. And I could be acting unethically if I put a 10% in there. I better be careful.
Yeah.
I don't know what y'all think about leaving it blank versus putting a 3 to 10%. I mean, I think in general, 3 to 10% per annum is what I saw on other.
Mhm.
You have 3 in your sample. You have 3.
I went with the lower one.
Yeah. So you have 3 in your sample. And I mean, do you have to give a specific number? Do you have to give a specific range?
Yeah. This is the slippery slope we're getting on now.
Yep.
So,
I like that your sample's pretty low.
Right. So I went with the low one and said what I thought was low.
Yeah.
This is fine.
Mhm.
If you go above that, then you have to look more closely at whether it's.
But that's what a guideline is. This is, reasonable to this committee and will be reasonable to the ethics committee. And if somebody decides 3 is too low, I'm going to put 10 in my agreement, then he's taking his chances. It might be found to be clearly excessive. 3 is not going to be found to be clearly excessive.
well, if we give whatever we give, it's going to be hard for us to say it's excessive if we put a number in
Exactly.
there.
Yeah,
Hard
so
for
we should
grievance to
use
say
the
that,
low.
and so.
Well, that's why I put the 3,
That's why she put the
That
low.
is baseline.
a baseline.
Look, I'll tell you, on that last sentence, I hear what you're saying, Martin. I think that says nothing, because that obligation is already in our rules of professional conduct. It's already in there. So
It is.
that last sentence simply restates what is already imposed by our rules.
It is, but the clients don't know what our rules are. That's for the
But
client.
the
Client's
lawyer's writing this, and the
Mhm.
lawyer knows that by putting that in there, he's not doing the client a favor. He's simply complying with the rules.
Well,
And he's
I think
supposed to, remember, he's supposed to explain all of this to the client anyway. So
that's
that's
right.
just one, this is a 5-page opinion, and I don't know how long the fee agreement with the client's going to be, but it's probably going to be one section of a, contract between the lawyer and the client. And so how many of our clients are sophisticated enough to fully understand what's in those things anyway, is the truth be known. If you're dealing with in-house lawyers, yeah, but if you're dealing with folks off the street, maybe not. But we can move on. I got one other question. But that last sentence, Suzanne and Brian, is that our green light to say to other practice areas that you can tailor anything that you want to your practice area? Law firm may utilize a unique fee provision specifically tailored to their practice and clientele. What is that intended to say? Is that intended to say to other practice areas other than estate planning, which is the subject of this inquiry, that you can also go out and draft some unique provision that suits your practice area, so long as you follow this opinion? What is the intent in that last sentence there? And that language in particular, you can tailor your provision to your practice.
That was not the intent for it to go to other practices, but I think that's something that might happen if this opinion is adopted. It was just meant to say this language is not the only language that you can use. You might have a big practice or a small practice or work in a rural. It was just trying to say, it's going to be fact specific based on your practice and your clients, what is reasonable and what it was just honestly to give a little bit of flexibility and emphasize that this language is not the only language that would be permissible.
Well, but there's also nothing that would prevent, for example, I think I heard this at some of the prior meetings, and Gina's on the phone so she can speak up. I heard some of the family lawyers say, we want to put this in our contract as well. And then there's nothing in this provision which prevents Gina from saying, I'm following the same thing that this opinion says, even though it's written for an estate matter. I'm following this exact same opinion and putting my provision in my contract, and so I'm golden. There's nothing that prevents other practice areas from saying doing the exact same thing we're saying to the estates area specifically you can do per this opinion.
Well, I don't necessarily think that we're trying to say specifically that it's limited to estates. I mean, that's what the inquiry is, and that's what the answer is. But we know from our research that other areas are already using this. It's already being used in mergers and acquisition contracts. It's already being used in family law contracts.
Well, you're right. So basically, that was my question. So this is the bar's green light to the membership that you can use this if you want to, because it's already being done, and now we're saying the estate lawyers can do it. And so Gina wants to do it, or if I want to do it, anybody wants to do it, it's okay. Is that what we're saying?
Why wouldn't we want to say that, though?
I'm asking because that's not the inquiry. The inquiry is unique to estates.
Right, it is, but eventually someone will have the question, and the inquirer was going to come to Suzanne or Brian. Hey, I'm doing family law. Can I do this too?
Exactly.
Well,
And
that's my point. I think that's exactly, and I think Gina just confirmed that's exactly how other practice areas are going to review this, when the inquiry was very narrow, and this opinion sort of says it's okay for any practice area to do it. It's sort of, sometimes you stick to the question before you going out and say any practice area in North Carolina can follow this.
I mean, I can change that sentence to say your specific estate planning practice and clientele. But I think the analysis, Todd,
You
is
could
going to
also,
be the same,
Suzanne, you
regardless.
could just delete specifically tailored to their practice and clientele, and the sentence could read, law firm may utilize a unique fee provision as long as the scope of the provision is limited.
I think that, or you can just strike it, because that's repeating what we've said several times in the opinion already. That last sentence is repeating what we've already said.
Okay.
I think you can strike it too, because it says the sample is not the only language that's permissible.
That's right.
Well, And I wonder, I mean, what we're doing, hopefully, I mean, it may have broader implications. And if we thought it through well, doesn't it help everybody?
Yeah.
Exactly.
That's
I don't
my
know if we
point. I
thought
mean,
it through well.
well, the analysis is going to be the same
Well,
regardless of your practice area,
Well, okay.
in my
But
opinion.
I do think though, I think you've tailored this decision for estates. You know,
That's
when I
right.
read it, you were very clear in your language. This was about estates. I mean, that's the
That's
only
right.
thing we're giving people the green light on in this opinion.
Right.
Can other people make assumptions or act upon it in a different way? Perhaps, but I do think that the language you have is narrow because I've specifically looked at that when I reviewed it. I mean, you say it's to the estate's practice multiple times in the language.
The only
Because
other, I agree with that. The only other thing I would say quickly is if you look at, go back to that statute again, 6-21-2, the last sentence talks about attorney's fees and actions for alimony shall not be included here because there's a separate statute, 5016.4, that addresses that. So, I mean, you know, that if you look at this statute and that last sentence, it would say that even 6-21-2 doesn't apply, or 6-21 doesn't apply to alimony family law because there's another statute. So I'm not sure if we need to broaden it if this is a narrow
There's
estate
statutes
planning.
unique to every claim in family law that deal with attorney's fees.
I agree with that, but they're not. There are lots of other practice areas where they're not, and this statute pointed out specifically that family law is exempted from 6-21. That's my only point.
Alimony, but I'm just saying there's a whole bunch of other
Yeah, I
claims
know.
in family law that
Yeah.
are not alimony.
Well,
Right.
just as an aside, this provision is only intended to apply to the situation where lawyer is being called in after the fact to testify or otherwise contribute to some sort of kind of collateral proceeding. It's not necessarily supposed to be a substitute within the alimony case.
I know, and it couldn't. I don't think it could.
And
But
I don't think
these
it
aren't-
can.
the statute, yeah.
Yeah.
these aren't attorney's fees in the classic sense of the word.
That's right.
Exactly.
So I think I'm going to recap where I think we are on a couple of issues because I think we have some consensus around a few issues. So one is we agree that we're going to strike subsection or sub 3, the request for information arises out of connection with work we're doing for you. That's in the sample language. We agree to strike that sentence, that next to last sentence, law firm may utilize a unique fee provision. And then we want to add that statutory footnote. Does anybody disagree with those 3 changes that Todd has proposed? I think we've got agreement on that. Okay. So the only question that Suzanne had asked us to give her some guidance on is back up there in the paragraph that begins, it is important that the client understands, that has the percentage per annum or the maximum rate. Did we want to put something in there, or do we want that to stay vague with, you know, the sample language showing 3%? That's some guidance to lawyers about what we think might be reasonable. What do folks think about that?
I don't think you can put a maximum rate as far as per hour because my hourly billing is a lot different than Charlotte.
Yeah.
I
It would
love
be
to
hard to
charge
put
Charlotte.
a specific maximum billing rate in
I'm
there.
surprised at that, Martin. I thought you were higher than Charlotte.
That's
I
right.
wish. I would love to do some Charlotte work for you, though. You let me know.
Yeah, I don't
People had
think
to
you
get
can.
paid on Charlotte rates.
I don't think we can see, that's where I'm thinking about this. You craft it specifically to your practice because, you know, if the current rate is $300, the max is going to be different than if your current rate is already $600 or $1,000, then the max is going to be much, much higher.
I think it's better just to leave it the way it is without a number.
Okay, so just some more vague language. So
Well,
Suzanne,
okay,
you
why
draft
don't
that
we
one.
just strike that too? I mean, why don't we stop it at adjustment clauses? I mean, because this is all saying the lawyer has to explain all of this to the client. I mean, do we need the rest of that paragraph?
What do folks think about that?
What this is saying is it's a lawyer's duty to make sure that all of this is understood, I guess, must be clearly explained in the retainer agreement. So it's his or her agreement. Do we need that, for example, language?
Well, I think it's helpful for me if I'm a practitioner, not in a firm that does this all the time, and having some ideas about how I could craft it. Not that I would necessarily take the percentage or the maximum per hour. I wouldn't know, but you know, it seems like that's giving instruction to me as I'm crafting my fee agreement and putting in this provision. At least I know I've got kind of a guideline of 3% looks like it's probably good.
I thought it was providing more guidance, and that was what we were trying to do. But maybe it's too much guidance. I don't know.
I just think there's some contractual difficulty with agreeing to agree to something into the future, and that agreement rendering provisions indefinite. I've litigated that before, but
Well, that's the whole question. I mean,
well,
Yeah.
I
if we can't-
still believe that is a question. But I mean, do we really? I mean, I guess it sounds like consensus. We need to leave something in there. I would be fine leaving it out, but if the will of the group is to put something in there, then so be it. I mean, it can't be different than if we're going to use 3% down in the example, then are we going to put anything other than 3% in that sentence?
Well, it'd be a risk that you take, but I mean, if you're willing to take the risk,
I think
if I
it's
put
fine.
5%.
I think it's fine the way it is personally, but
With nothing, with no percentage in there?
in just the example, saying, for example, you can look at adjustable rates percentage per annum, or you can look at a cap. And in that sentence, we're not saying what the specific percentage is or what the specific cap is, just saying these are two methods that you can use to allow for a flexible rate. And then in the specific sample provision, I picked 3% just to make that a specific sample provision with all the numbers filled in.
I liked it that way, and I liked it that she picked probably the lesser of all of the options in the sample language that we were giving. I think doing it that way is erring on the side of protecting the public, which is what we're always supposed to be doing.
I say let's publish it and see what we get back.
I agree.
Second.
I agree.
I mean, we gotta.
Get off the Potter fee.
Well, I was
Fish
gonna.
or cut bait?
I was gonna. That's exactly what I was. It
I
was.
was gonna say fish or cut bait. Mine is
No.
more
I
politically correct.
had what Martin had in my head, and I stopped myself,
I'll say it for you.
which is good for me because I don't usually stop myself.
Let's grab a kind of consensus with the 3 changes that we talked about. And everybody, I don't need to go back over those, I don't think. So why don't I make a motion to approve the opinion with the 3 changes that we just articulated? Is there a second?
Second.
I'll second.
Okay, all in favor?
Aye.
Okay, so Suzanne, this will go in front of the ethics committee at the next meeting.
Yes, I'll
With those
make
changes.
the edits and get that out to you guys.
We gotta be sure Todd is needed somewhere else. I don't want him making
gonna be in agreement.
when we're talking
Good
about this.
changes.
We're gonna lock the doors.
Let me look at the meeting schedule and see what else we have going on.
Let's double book him.
Thought y'all just agreed to accept my 3 helpful recommendations.
We did, but you're not
Now you
gonna
hurt my
stop
feelings.
there.
Yes,
we
we
know
do.
you. You can't let it go.
You're
We've tried to
pulling up
beat you down for
statutes and
years.
stuff.
You won't have me to kick
Okay,
around much longer, so I'll be gone soon. Don't worry.
No, stop it.
I'll say to that point, this needs to pass at our next meeting because it will be my last meeting.
I
So my
know.
term, I'm only doing 1 3-year term on the state bar. So my term ends at the end of the year. So I just want to see how much I've enjoyed working with all of you. And maybe I can get somebody to appoint me as an advisory committee to something, hint, hint. But also want to thank you, Gina,
Matt Smith.
Gina, thanks for your great work before I took the helm. And Suzanne, you've been a great leader, and Brian, a great support. So thank you both. I think this is great work. I'm proud of this. This is great.
I think
And-
it's a good starting point
Good
anyway,
start.
so.
Thank
All right.
you.
Thank you.
Thanks,
Suzanne.
everybody.
Thanks, everybody.
y'all.
Have a
Thank
great
you,
day.
Todd. We love